Jonathan Lederman from LSS Law, and today I want to answer the question of what is a proof of claim in a bankruptcy. Now, as a debtor, you may come across this if you're trying to file bankruptcy by yourself. If you've already hired an attorney or you're thinking of hiring an attorney, it's really not something that you need to worry about. And if you come across this video as a potential creditor in a bankruptcy, then it's very relevant for you. So a proof of claim form is an official bankruptcy form that a creditor who's owed money by the person or entity that filed bankruptcy needs to file with the court to make a claim to getting paid within the bankruptcy. So every creditor, whether it's a friend, family member, credit card company, medical provider, the IRS, mortgage company, whoever it is, if they're owed money by the debtor who filed the bankruptcy, then they are required to file a proof of claim form to share in the proceeds or distributions that are going to be made within the bankruptcy. Now, in a Chapter 7, a proof of claim form is not filed off the bat. It's not even provided to creditors because it's assumed to be what's called a no asset case, in which case there won't be anything to distribute to creditors. But if something happens in the middle of that case where the Chapter 7 trustee thinks that they will be collecting money to distribute to creditors, then those forms will need to be filed. In a Chapter 13 and 11, the creditors do need to file them. There are deadlines by which these forms need to be filed. And if a creditor is owed money but fails to file a form, then typically they don't share in the distributions. There may be strategies involved, more particularly in a Chapter 13, I would say, or a Chapter 11, where the debtor or the debtor's attorney can file a proof of claim form on behalf of a creditor who hasn't done it, to ensure that the debts are properly administered. So if you are ready to discuss the possibility of filing bankruptcy and you'd like to sit down with myself or one of the other experienced attorneys in my office, we offer a no cost, no obligation bankruptcy strategy session. To schedule that, you just need to call the number below. If you're not quite ready for that step and you would like to gain access to some of our other resources, or you'd like to watch other videos in which I answer additional frequently asked questions, you can gain access to those resources by clicking on the links below. Please remember, doing nothing changes nothing. And doing nothing is still making a decision whether you realize it or not. A pretty poor one in my opinion. So I encourage you to simply take action. You have nothing to lose. We're here, ready, willing, and able to help. All you need to do is pick up the phone. I really encourage you to do so.